get started. So I know last class was intense. We did the real estate math. Now we're getting into all of like the Virginia portions and everything that's applicable to Virginia laws and regulations. We're practically done, you guys. With our, kind of with our sections here. There are a few other new introductions, but like I said, once we get past the math, it's all kind of reiterating some of the things that we've already touched on. So let me pull this up and I'll share screen. Okay. So unit 4 is the last kind of section in our course and time together. We have all of Virginia law and regulations. So we'll talk about licensing. We'll touch again on escrow accounts and disclosures, um, agency definitions. You'll be reintroduced again to fair housing. And again, I just want to stress the importance of fair housing and then specific acts pertaining to like the real estate practice. So a lot of these chapters are small, very quick, and most of them you've already visited before. So we'll jump into licensing. Have we talked about this? Let's see, I don't think, no, we went ahead with one subject. Um, I think I have talked to you about the
We
board.
we skipped over one last week. We did
Yeah.
the math, and then we skipped one and went to the one after.
Okay, yeah, I remember we skipped and then we did the evaluation one on Monday too. Okay. So if this seems to be familiar, just let me know. The minimum licensing standards of Virginia. I think we talked about this. What you have to be to apply to get your real estate license. We talked
Yep.
about the hours and credits. Okay. Let's just go past this. And so who needs a real estate license and who doesn't, who's exempt. So yeah, felt like this was just spoke on this. So get into escrow accounts. Like I said, very small chapter. It is something that we are going to have to know. One of the things that we do pertaining to our careers and our lives day to day as an agent. So in this section, we'll talk about the establishment and maintenance of escrow accounts, the types of violations pertaining to them, the duties between the salespersons and the broker as it relates to how you deal with the escrow accounts, and talk about the funds that may be withdrawn. So to establish an escrow account, and let me just back up here. An escrow account is like a third-party neutral account. It's an account set up that represents that money can funnel through for that specific transaction. Usually it's done for earnest money deposits. So the buyer would deposit their earnest money funds in there 5 days after getting under contract. But sometimes earnest accounts can be used for a number of different reasons. So establishing them, they're only required when holding money or property for others. It must be in the firm's licensed name, opened at a federally insured bank, must be labeled as an escrow account on all of the accounts and deposits. It needs to stay escrow. Like I said, used to hold earnest money and security deposits. Within the contract, it states that the funds must be deposited within 5 banking days of receipt, application, or ratification. So if I write an offer to a seller, today's Tuesday, and they don't accept it until Friday, my business day, well, my 5 days technically does not start until Monday, because the banks do not operate on the weekend. So my day one will begin Monday, and I would have 5 business days to make sure that this is in before the close of business. So, and it may exclude any holidays, but it is 5 banking days from the time that we become ratified. And then all parties must approve in writing for interest-bearing accounts. Your broker that you affiliate or who you sign to, they may do things to where you are to give them your earnest money and they, put it in their accounts. I've done a few transactions like that, but normally I just take mine to the title center that I plan to close at. It just makes everything seamless when it comes time for closing. Everything's in one place. It's easier for me that way. And then going back to the title company, I don't know. So it is held in an account specifically for the transaction that we're working on. For the most part, I don't think it's in an interest-bearing account. Like I said, we would have to sign off for that. And it would be in the transaction name. So if the firm is holding it, it'll be in the firm's name. If it's with your title company, then it's probably going to be labeled under the address that the home is listed under. So maintenance for an escrow account. So fund management is ensuring that timely deposits are made and proper disbursement of funds. Compliance and auditing. There is to be regular compliance to abide by state laws and to cooperate with other regular audits. So that's why it's important to make sure that they're in the right accounts, they're done properly, because you never know when things may happen and you may need to do a random audit. um, Communication with parties. Be transparent with all parties in the transaction and prompt response to record request. Normally, what I do, I drop the earnest money off, or the buyer drops it off, but I always ask for a copy of receipt. So it's my title center. What they do is like initial whoever took the check in, they put like their little stamp on it. It shows that, it belongs to me for this house. And what I do is I either get that copy while I'm there or I get an email and then I send it over to the listing agent to let them know, hey, full transparency. What we said we're going to do, we're going to put down this $6,000 earnest money at this title company, and we have. So I just like to do that to communicate that we've deposited something into that account. So that way they know. In handling disputes, follow proper legal actions for dispute, filing interpolator actions in court. Again, because I do things this way, and I think most agents, will attest to either it goes to your broker or it goes to the title company. There's usually not any type of legal action that takes place. Now, if someone were to maybe cancel out of a contract before, without just reason or before, closing, then there might be some things to where the seller may be able to hold on to the earnest money because the buyer is at default. But usually it doesn't have to go all the way to litigations, but that is one way that things can be handled. So now we're getting into the types of violations that can occur with earnest money accounts. So commingling of the funds is the violation, and that's when you're mixing personal and business funds in an account together. For an example, a broker deposits personal money into the escrow account or uses the escrow funds to pay for business expenses. Conversion or misappropriation of funds is when using your funds for purposes other than those for which they were intended for. So let's say a broker uses the earnest money to deposit to cover operating expenses, personal bills, to buy new signs. Like, we can't do that. It's specifically for the transaction in which is being held. Another violation is a failure to deposit funds properly, not depositing received funds into escrow accounts within the legally required time frame. Again, the contract that our buyers sign that our names are attached to are legally binding documents. You can go to court for them. They're, concrete, kind of like the law and the Constitution. Like, so the things that are written on there are things that we have to abide by. So if we say that we're going to have that within 5 business days, then we need to have that. Also, another thing, I know I showed you our contract, and so a lot of things are pre-filled, but if there are things that you may need additional time on, let's say, I don't know, your buyer's going out of town, or for whatever reason the account is froze, you can always cross out things in your contract and write over. So if you need more than the 5 business days, what I would do when it came to that section on my contract, if I needed to, I would cross that out and maybe say 7 business days or 10 business days. and have my buyer initial beside that. And then the seller would also initial. So there are ways around it, but you have to be transparent. And let's say that you go into the contract and, forbid something happens, like, death in the family, and maybe the money that they needed, they have to go burial expenses. So if there are things that came up, you can always do an amendment or an addendum to your contracts. And we should touch on that in disclosures. But if you know that something is going to come up, or you know that you may miss a deadline, it's best to either catch it up front or to amend your contract, and have all parties sign off on it. That way you can avoid all these, violations. But it does say on the contract 5 business days. If you need more time, adjust the contract. Another violation is inadequate record keeping. So failure to maintain accurate and detailed records of all escrow transactions. And also dispersing the funds without any authorization. Those funds do require proper authorization before the transaction conditions are met. Um, releasing them before these things are done would be a violation. So um, you need to have authorization, and it needs to be done at the appropriate time. But again, these are things that we as agents don't necessarily handle, but it is wise to keep track of that to make sure that, your buyer's earnest money didn't go to the seller before, all of their repairs that they said they were going to do were done, or before closing. So it's good to know these things so you can stay on top of your transactions. Another violation would be inadequate supervision. So failure to properly supervise employees handling the escrow funds. Being in an interest-bearing account without disclosures. Remember, if it is in an interest-bearing account, it needs to have disclosures and permission for all parties. And failing to return funds properly. So not returning them to their rightful owner promptly when the transaction is canceled or fails to close. You know, um, again, these are things that we don't actually, initiate ourselves, but still good things to know. So if, like I said, our buyers back out because, we find out that, the roof got major leaks, and we're backing out during our inspection time frame, and we've wrote it in our contract for us to get our earnest money back. Well, if they're waiting, and it's been a month since we've got our money back, these are things that you need to know as an agent. That way you can protect the buyer and their funds. So potential consequences for escrow account violations. So there can be legal penalties, fines, penalties, other legal actions can be taken place by state regulatory agencies. Your license could be revocated, so loss or suspension of the broker's license. Um, your reputation could be damaged, loss of trust and credibility with clients and within the industry. Let me just stop there also. Even not only not only escrow violations, but the real estate, although there are about 1,600 agents, 1,600 agents in the Roanoke Valley, it's a very small community. Although things should be confidential, a lot of things get out there. So you just want to always uphold kind of your integrity, your ethics, because you don't want to start to have that negative stigma around you or the things, travel fast, especially amongst agents, within our office. I hate to, describe it sometimes as like high school, but sometimes it can be. But just make sure that like you're acting in good faith. Because like I said, don't want to lose credibility with other agents. Sometimes, if the contract is neck and neck, maybe you have an identical offer as someone else and it's down to each seller can't make a decision. Well, sometimes your realtor's influence can come into it. And if they say, well, I've had, bad experience with such and such, and last time they stole my client's earnest money and this and that. But so just watch that and make sure you're not creating a just a bad reputation about yourself. um, and financial losses. It can be direct financial loss to clients and a potential lawsuit for damages. Again, we don't want to mess with any of that or have our clients in litigations. Um, so ways to prevent escrow account violations by having regular trainings, ensuring that employees are knowledgeable about the legal requirements, having some type of internal controls, strict systems and processes, regular audits and reconciliations to detect discrepancies, and compliance checks, regularly reviewing compliance with state-specific regulations. These are all ways that they go about to try to prevent escrow violations. So here are the different duties between the broker and the salespersons when dealing with escrow deposits. So the broker may be one who establishes the account and signs off for it. They are the primary ones liable for the account. And if there are any violations, they must report it to the board within 3 days. Now, as a salesperson, you all are only going to be responsible to deposit the funds properly. You could be held secondly responsible for any liabilities on the account. You can still be held responsible for conversion and commingling. Again, like I said, I would either hand it to our office secretary, if you want your escrow deposits to stay with at your firm. If not, give it to somebody at the title company. That way, all liability is off of you. And again, these are just the duties in a chart form. Okay, so when can they be withdrawn from the account? So the funds, that are held in escrow are typically withdrawal when the transaction is consummated. At closing, because if you think about it, it's all going towards the transaction. So we put down the earnest money as a good faith deposit, and that all gets credited back to you at closing. So it gets calculated into your closing costs and what you have to bring to the closing table. So that's usually when the escrow accounts are dispersed. You may also see funds withdrawn from the account when it's mutually agreed upon by all parties. So again, like I said, when you, let's say for any reason we need to cancel the contract, if we are within a time frame or a portion within our due diligence that we can exit out of the contract and keep our earnest money deposit, it's definitely going to go back to the buyer. There is a specific form that we are to sign, and it indicates who is getting the deposit and what reason for. And again, anything that you give to the other side of the party has to be signed. So it's presented to the listing agent, and then they present it to the seller. They sign off on it. We give the form to the title company, and then they give the earnest money back to the buyer. Now, it could be a situation where the buyer is not in a position in a contract to where they can, withdraw and walk away, get their earnest money back. Sometimes these funds go to the seller. So this is why I'm always careful to tell my clients, hey, it is a pre-down payment, like a good faith deposit. You can get these back at certain times, but it is something that you may have to walk away from if the house just doesn't work for you. Um, and then by court order is also another way that the escrow accounts can be dispersed. Now, commissions, they cannot be removed until earned and all parties agree. And if there are insufficient funds in the account, you cannot use funds from another account to cover another. And again, the insufficient funds would not happen if no one was commingling in conversion. So usually that's not going to happen. So an example of dispersing escrow funds, let's say Broker Smith is managing 5 different apartment buildings. Scenic View Apartments needs roof repairs, and the owner authorized Smith to pay for the repairs out of funds held in escrow. The bill for the roof repairs is $2,000. Broker Smith's escrow account has a balance of $10,000, but Scenic View only has $1,500 in the account. Broker Smith may not withdraw more than the $1,500 that specifically belongs to Scenic View. So That is an example. We'll get into the progress check, just to check our knowledge. So the third party money must be deposited in an escrow account within how many days?
5 business days? No, 3 banking days.
We have 3 banking days, 5 business days, 5 banking days, or 3 business days. You want to stick with your answer of B, the business days or banking days?
I say business days, but it's bank.
Banking days.
Okay.
Although, depending on, I guess, where you live geographically, they both kind of mean the same thing. And this is a question kind of where it's like, what are the better of the two choices? Like, we know business days and banking days are usually the same. Well, let me say this. Business days are usually Monday through Friday, but banking days, they account for any holidays, you know. So if you're ever stumped with this, it's always going to be the banking days. Make sure you just read that carefully. Um, all of the following are acceptable reasons for escrow disbursements, except what?
A verbal request of the buyer.
Yeah, but I can't just say, if that's the case, everybody would get earnest money back, and it's just too easy that way. But yes, you cannot get earnest money back just by a verbal request. It has to be agreed upon. The transaction has to close, or it can be done by court order. And so, who is responsible for and has the authority to establish a firm's escrow account?
The broker.
Yep. So if a firm's escrow account is an interest-bearing account, what must take place prior to placing the earnest money deposit into that account?
All parties to the transaction must be informed and agree in writing.
Yeah. And that's going to usually be the same with anything. So once you're under contract, both parties have to agree. So one party can, and let's just say, let's take into the example that I gave, where let's say, you needed an extra day or two to bring your earnest money deposit in. If you need to do an amendment or, and change the contract, both parties have to do it. And let's say the seller doesn't want to wait for you to have these extra 2 days. He's within every right, to do so. So just, always sometimes may have to negotiate even past the offer stage, but yes, they all must agree to it in writing. Any questions about escrow accounts? They're pretty simple. I usually just don't I don't at all deal with them. I just, go ahead and make the deposit, go back about my day. I think most brokerages, I would assume, have a lot of other day-to-day things to go on. Um, handling compliance, reviewing contracts. So I just feel like it's best to keep it as a title center. It may be different depending on whom you're asking, but that's just my way of doing things. So this next section on disclosures, you may see an additional 10 questions on this topic on your exam. We'll go over a little bit about our disclosures that we have specifically for Virginia. So we have the Virginia Residential Property Disclosure Act, Inform. We'll talk about the purpose and requirements of that. Recognize the disclosures provided and required by the board. Identify seller required disclosures. Buyer's responsibility for due diligence. Go over some specific regional rules and proper timing for these disclosures. First one we'll touch on is the Virginia Residential Property Disclosure Act, and that is um, imposes properly disclosure obligations on seller and licensees. The sellers must provide this form and statement to the buyer. The form is on the Depot website. It's also on a few other sites that we use day to day. But that is for the seller to make any disclosures about the property. Um, and if we are knowledgeable about anything, we need to also be disclosing. Now, this particular form only applies to residential 1 to 4 unit properties. It does not apply to foreclosures, eminent domain, bankruptcy, estate settlements, new construction, divorce settlements, and family transfers. That's going to be something that they're probably going to put in a question form for you. I think it is one of our, it's either in the progress check in this section or section 2. But yeah, it only applies to single family units up to a quadplex. But it doesn't apply to anything new construction, condominiums, apartment complexes, or any of these that are listed here. But this will definitely be brought up in a question. So what is the purpose for this? It's for buyers to be aware of matters affecting the decision to purchase the property. So the licensee, our requirements is to inform clients and customers the rights and their duties under the act. And for the sellers, they're obligated and they are required to give this form to the buyer. The buyer, however, is advised to do their own due diligence. Again, Virginia is a buyer beware state. So although a seller is supposed to disclose any pertinent facts to the property, it is still up to the buyer to do their own due diligence. Um, and that works sort of like, let's say the seller may be unaware that there are, radon in the house, or let's just stick with radon. They may not know that there's radon in the property. Buyer buys the home without doing a radon test. And then they end up sick, with radon poisoning, or, however radon affects, they start getting sick. They would not be able, I wouldn't say they wouldn't be able, but it's most likely not going to hold up in court because, for one, radon is something that you can't smell, taste, hear, smell. You can't touch this type of thing. So the seller could have just not had any knowledge about it, as well as the agent. This is not a test that we do when we list a home. This is the test that's performed for the buyer. So if the buyer opted not to do their due diligence, if they opted not to do their home inspection, their radon inspection, then it's really, it's really sorry that, you're sick now with radon because you were supposed to do your due diligence. So although the seller is required to note of anything that they know of, the buyers have more of a responsibility in the state of Virginia. Other states don't always operate like this, but that would probably not hold out well on the buyer's end because they opted not to do the inspection for radon. And then so here are links. And so just go ahead and click on these so you can see. So this is something that goes on with every listing that I get. I have to give this to the seller. This is the form that you'll use. So again, here we just enter in the property address. And so all the disclosures are here. So this says it's to provide notification to the purchaser of disclosures required by the act and advise the purchaser that the disclosures are listed on the real estate board website. Gives them a link. The owner hereby provides notification that they're informed of what's going on with this act, and then the purchaser would also sign here. So this goes along with your transactions. And we have so these are all the things that they are requesting that the buyer do their necessary due diligence on. So the top part here says the Virginia Residential Property Disclosure Act governs the information owners must disclose to prospective purchasers of residential real property. Certain residential property transfers are excluded from the requirements. You'll have to see all that information below. But the owner makes no representation or warranties as to the condition of the property, restrictions or conveyances. The purchasers, and I'm here in this paragraph, the purchasers are advised to exercise whatever due diligence a particular purchaser deems necessary, including home inspections, mold assessments, energy analysis, um, in accordance to the terms and conditions contained in the real estate purchase contract or prior to settlement. The lot lines, the owner makes no representations to the current lot lines or the ability to expand, improve, or add any structures. Purchasers are advised to again do their due diligence, obtain a survey, contact the locality to determine zoning, lot coverage, height, setbacks, and requirements on the property. So a lot of people, especially when you're purchasing land, and even I see it on residential. I had a listing appointment was last week, sometime over the past week, and all my days are running together. But I went to a home in Salem, and the property owner, let me know where she thought the lines were, and of course, it was already marked. She lives in an HOA subdivision, so sometimes those things stay in place. But an owner is not liable or not required to know exactly their lot lines or know exactly where the property line is. A lot of times buyers may ask me, a lot of time other agents may ask me, but the owner doesn't really have to know. It is up to the buyer to do those surveys of their land. It is always a good thing if the owner is able to have it, but they're not required. It talks about adjacent parcels, historic district ordinances, um, resource protection area. This is another one, and this is also in our contract. So the owner makes no representations, and I'm on number 6, about any sexual offenders in the area. It is up to the buyer to do their due diligence and go onto the appropriate websites to see if there are any registered sex offenders in the area. I mean, your neighbor could be one, but again, the owner, doesn't have to disclose that. Um, these are about dams, wastewater systems. The seller, makes no representation to the presence of any waste system, including um, the size of it, the presence of it, any cost requirements related to the pump out or clean out of septic tanks. So, the buyer we're putting a lot on them as we continue to go down the list. We got about solar energy, special flood areas, easements, community development, marine clays, radon gas, defective drywall, lead pipes. Um, so again, sellers and buyers may need to complete one or more of the following written disclosures. So there may be additional disclosures that need to be filled out. But if you go through like page 1 through 10, these are all the things that a buyer should be getting done within their due diligence. Like I said, although the seller should be making aware of these things if they are knowledgeable about it, it's usually not it's usually just not required. So this is what this form tells them. It basically protects the seller, it lets them know, hey, these are all of the things that should be brought up, but you're not really obligated to. And here, sign here, letting you know that I've given you this, but you don't necessarily have to. You should, but you don't have to. You're not required. So that is that form. Again, Virginia is a buyer beware state, and I would highly advise all of my clients to at least do a home inspection. Radon would be another one, especially for just for honestly anybody, because you never know how it could affect you. There are a lot of symptoms that come along with it. Um, people will have pets. That's just like another $125, $20 inspection on top of your home inspection, but it could be life-saving. And then if there's anything found, most of the time you can negotiate with the seller to pay for that. Um, Now, it's going to be case by case on whether you need to do any additional inspections. So sometimes the home inspector may say, hey, on that wall over there, it looks like it may be mold. You may want to contact, a mold company. Um, there may be signs of termite damage, so now you have to get that fixed. So start off with those, and then those can, just peel back different layers or request different type of specialties to come in and help you. Um, So seller required disclosures, real property owner required disclosures. If they're in any area where there's a lot of air traffic noise, there's a septic disclosure, defective drywall, building or zoning violation disclosure, tourism activity disclosure, and a methamphetamine disclosure. A lot of people are, taken aback by that. But yes, there is a disclosure um, around if a home is maybe used for methamphetamine gas creation and maybe not properly cleaned and sanitized. That is a disclosure that is required. So there's also some limits on the disclosures. So owners are not liable for the errors in information provided by third parties if they are unaware. So let's say that our tax database, our tax records maybe are showing something different, or maybe, I don't know, somebody's editing posts on Zillow or whatever. So there is some liability and some limits on how far you can go for violating that. And owners are not liable for new information which renders prior disclosures inaccurate. Okay, and so we went over this list about the things that they don't have to make any or give any warranties to, or matter of fact. So this is that list again that we just saw in the form. These are specifically to the Chesapeake Bay preservation areas and the Tidewater areas of Virginia, but they have their own set of rules to protect the public interest. So they incorporate water quality protection measures, establish programs to define and protect the Chesapeake Bay preservation areas. They make their own resources available by their local governing bodies and exercise delegated authority consistent with the water quality protection provisions. So because they're in that area, just has another safety measure. So disclosures or disclaimers must be made prior to the buyer's acceptance. You know, if not, the buyer has the right to terminate without any penalty by providing written notice to the seller. It's like you can't advertise a beautiful home for sale, 7 acres, white picket fence, move-in ready. And then when the buyer accepts, you say, yeah, but we're, hoarded by termites and, they're eating away at the structure. These are things that need to be disclosed before the buyer accepts and goes on a contract with you. And that's what that timing measure means. Any questions before we go into the progress check?
No, ma'am.
Okay. So seller disclosures must be made prior to what?
A buyer's acceptance of the contract?
Yep. Yes. And technically all of these are correct. But again, the better or the most correct answer is before they accept. And like I said, if it's disclosed how it should be in the MLS and under the property information, it would be done before closing, definitely before the closing date. but matter of fact, it needs to be done before they accept the contract or the buyer has the right to terminate. So which of the following types of property transfer is covered under the Virginia Residential Property Disclosure Act? Which of the following types of property? So this is talking about when we talked about that slide on which things are excluded from having to have these disclosures.
I said,
Remember, I'm sorry,
said
go ahead.
sale of a duplex valued at under 500,000.
So no. And they make these questions long and filled with other information. So I was gonna say, let's go back and think about it. The residential property disclosure is 4 units from 1 to 4 doors.
Oh,
So duplex is only 2, so we would eliminate choice number C. Property transfer from her aunt to her nephew. Yes. Let's see. Eminent domain.
B.
Yes, the subdivision. Oops, wait a minute. What is going on? Let me go back to that one. This should have been an answer. We'll go back and check on that. In accordance with the Virginia Residential Property Disclosure Act, blank is responsible for providing a residential property disclosure statement to the buyer.
I'm so sorry. What was the answer for the last one? I got a little confused.
I'm going to go back to that one.
Okay, gotcha.
The seller.
Correct. So the seller is responsible for providing that. Which of the following is not something that the buyer is responsible to research or find under the buyer beware and buyer's due diligence standards? What are they not responsible to find?
About the sex offender in the area.
Yeah, they're responsible for that. The seller wouldn't know.
Okay. Which of the following is not?
Would it be nearby flood zones?
Well, that would be something that they would need to research within their due diligence.
Oh, so it's got to be material defects.
Yeah, because the seller should be making notice of all of those. So mineral rights attached to the property. The seller may not know they're sitting on a gold mine, but if this buyer wants to do their research, they can. They are responsible for locating the sex offenders and researching nearby flood zones. Let me move this and go back to, was it number 2? Oops. Let me see, did I hit the wrong button? Let's see. Is covered. You know what? My brain is fried. I think we were answered what is not covered. You were correct. I'm sorry. I think I was reading it as which one is not. So they would be covered, a duplex, because it's within those 1 to 4 doors. That's my mistake. Been a long day. But yeah, which of the following is covered? So a new construction would not be something covered. Family transfers, you do not need to have the Residential Real Estate Disclosure Act and also with eminent domain. But you do need it for duplex because it falls within this residential property between 1 to 4 units. Now, if it was a condo value, then it would not. But because it is between 1 and 4 doors, C, you're correct, is the correct answer for that one. We have a few more sections to go, so we're going to go ahead and take a quick break. If we want to get back at about 6:30, we can finish this on up.
Okay, thank you.
Mhm. So hopefully everyone is back. We are gonna go over to our next section, which is agency definitions and relationships. So then guess about 12 questions from this topic will be on your exam. It's a highly important topic. We'll get to learn about the broker, salesperson, relationships, and compensation, the different types of agency relations, how they start and how they end, disclosure requirements for each type of agency relationship, and the liabilities that we have as agents in the state of Virginia. Um, so broker relationships. You can either have a client or a customer. We talked about this before, but a client you have a formal written agreement with, and you owe them full fiduciary duties. Customers are non-represented parties. We owe them fairness and honesty only. And ultimate responsibility, ultimately responsible for actions of the salespersons dealing with clients and customers. Now, the salesperson's relationships, we can have the same as well with the clients. We represent the broker's clients and duties carried out on behalf of the broker. And customers, again, we treat them with fairness and honesty. In agency agreements, we don't enter into agency agreements ourselves. We are always in an agreement with our broker. So any of the, when we have a client who signs on as a seller or a buyer client, on those forms is always going to ask who the broker is. So technically your client is under contract, well, you are carrying out the duties on behalf of your broker, but all the contracts belong to the broker. You are just someone who carries out the duties of that contract. So it's still your client, you'll get compensated at the end. But the firm or the brokerage is the one who would own those. Now, setting commission amounts. Commissions are always negotiable. However, they can vary based on the market, the property type, and the services that are provided. There are no fixed rates. Standard commissions usually range from anywhere between 5 to 6% of the property sales price. Usually it is split between the seller and the buyer's agent. That's how it was prior to the settlements on August the 17th. However, now they are requesting that buyers, get into their own agreement with their buyer's agent to determine compensation. So it's not all the time that sellers, they're not required to offer anything to the buyer's agent anymore. They can, but we're not allowed to list that in the MLS. It needs to be something talked amongst both agents about if they are getting any compensation. Now the commission splits, the broker sets the split with the salesperson in the employee agreement. So that is whether you get, 75-25, 70-30, 60-40, whatever your broker commission split is what is going to be on every transaction. And that should have been given to you by your broker once you join the firm. So all compensation must be disclosed and approved by clients. Again, the seller must be aware of how much commission that he's giving out to you. And it also needs to be disclosed if any of the commission that he's giving to you is going to be given to the buyer's agency. Salespersons cannot receive direct commission payments from their clients, so that they're paid to the broker who then pays the salesperson. It's never directly towards you. The checks, when they come to or from the title company, they're most likely going to be in the broker's name. They find the transaction that it belongs to, and then they go give it to you. So these are the different types of agency relationships in Virginia. You can have standard, limited service or independent contractors, standard agency subject to all agency duties and disclosures imposed by Virginia law, and they're subject to any duties agreed to in the brokerage agreement. Limited service agency, they have fewer duties than the standard agents. They're held to duties not listed as an exception in the brokerage agreement. And independent contractors, they're not subject to any agency duties or anything specifically lined out on the brokerage agreement. Most of the time, you're always going to enter into a standard agency agreement. And like I said, that just gives your clients full, your full agency duties, the things that you agree upon on your employee contract with your broker, the things that are listed out in the brokerage agreements, the sales contract, and anything opposed by Virginia law. And like I said, normally people just don't operate in any of the others. I don't know as to why someone would hire someone not to give you the full benefits of the service. It's just like asking a lawyer to. I just can't see it being done. I think if I'm going to choose anybody to work with me, I want them to do everything within their powers. I don't want them to do some of the laws that they're, bound by. I want them to do all. And that's what kind of service you want to provide to your clients as well. It's, standard agency services, give them the best, abide by all the rules, follow all the instructions. And this is the same information, just in a different chart. So when are these agency relationships created? Agency commencement is when the listing or the buyer broker begin when the client engages the licensee. So anytime you reach out. So I put out a post today to try to talk about interest rates and grant money being available, and I had 2 people reach out, schedule consultations. So you would assume that this is when it commences. They've engaged me, they've inquired about my services, the one I'm able to provide, and my grants. So it would commence. We would officially be clients when we are signing our buyer broker agreement, allowing me to fully represent them. But it would be commencing now because the client has engaged with me. They filled out my form, they want more information. Agency termination, these contracts can be terminated when completed or the earlier of. So when it's mutually agreed upon, expiration date. If it's not specified, we're going to give it 90 days. Normally on all of our contracts, it gives when we're starting the buyer agency agreement and when it commences. So normally, depending on their time frame, I usually make mine just for a year, just to be on the safe side. And you said you can definitely buy before then, but I'm usually making mine, no more than, I would say, about 6 to 9 months to a year at the most. But again, it has a specified expiration date. However, we can both mutually agree anytime before that date. If for any reason we're just not a fit that we thought we were going to be together, we can both mutually agree to end our agreement with each other. By default of a party, these agency terminations can happen, and the agent wishes to terminate after the client refuses to consent to dual representation. So again, with the dual representation, when you're representing both buyer and the seller, remember the buyer and the seller both have to agree. What this is saying is if one party doesn't, agree to dual representation, I can fire them, or we can terminate our agreement. And what I would probably do is just refer it out. So if I had a buyer that wanted my listing, I don't want to do an agency, I'll find someone else in my office that, hey, can you represent this buyer and pay me a referral fee? So it's not like you're not getting off, scot-free. But you are able to still be compensated. So I love referrals. Referrals puts all the work on the other agent. They have to do all the running around inspections and things like that. And at the end, you get a 25, 30, 35% commission off referring that. So So disclosure requirements for each type of agency relationship, agent, whether you are standard or limited service, you need to list out, exactly what type of service you're going to provide, standard, limited service, or just representation. You need to also disclose how are you being compensated, how much are you being compensated, and whether a broker will share compensation with another broker. All of that needs to be disclosed upfront. If you're acting as a limited service agent, you need to state that and list out the specific services that you will provide in a list of duties that are required of a standard agent, just crossing off the things that you will not provide for them. So kind of giving them an option, seeing things side by side. And again, if you're acting as an independent contract, state that. Make sure you lay out and make note that you are not acting as an agent, and list out the specific services that you will provide as an independent contractor. So under Virginia, the agent duties for us when it comes to both clients and customers, when it relates to their documents, we are to store them in somewhere that's secure, confidential, and compliant with the state laws and our brokers' policies. I guess you can share some examples. There are programs, insights where you can keep them on, whether they be Loop, DocuSign. You can file, you go Google Drive, store them on your PC, but make sure that they're able to be secured, or maybe you need a password to enter in that file. So there's a lot of ways you can store your document, or you can do it old school and print everything out. Typically, you need to have these documents retained for 3 years. They could be subject to, audits anytime the state or broker needs to maybe check up on some things. You need to make sure that you have them at least stored with them for 3 years. You also provide provisions to the client. So promptly provide signed agreements and contracts in the preferred formats, either digital or physically. And documentation, maintain proof of delivery and organized record keeping for easy retrieval. Again, seems like a lot to do, but this is why it's important when you're researching your brokerages to see, what type of systems do you have in place for me in my transactions? Or what type of systems and technology do you provide to me as your agent working with you? You should have some type of transaction management system. Again, most of the common ones that we use is Dotloop, DOTLOOP. You have DocuSign. Some people may use Dropbox. But I would make sure that I'm checking out my broker and making sure that they have something for me to store my transactions in. If not, you do have backup Google Drive, storing things on your computer. But the systems that they use usually are more user-friendly. Like I said, secure. You have to log in every time to get to it, and it just makes it good to have all your transactions in one place. So that would be something that I would ask my broker about. We talked in a previous chapter about fiduciary duties, and they are to be obedient to our clients within lawful reason. We can't go commit the law just because we want to be obedient to them. We have to act, competently. But we owe our clients loyalty, disclosure, confidentiality, accounting, and reasonable care. And the acronym to remember that by is OLD CAR. Again, we've seen this twice in our text. This is going to be something that you are going to be quizzed on. So you need to know what all of these duties are as an agent. So you can bet it was shown multiple times for a reason. And even after, let's say, the client's, transactions have gone, they've relocated out of state or whatever the case may be, you still owe them accounting and confidentiality. You may have a question on your exam, which of the OLD CAR duties are, so which of these are only applicable to after closing? you need to know accounting and confidentiality. And they may jumble, you owe them loyalty and disclosure, so they may, but it's always going to be accounting and confidentiality. And I think the way that I remembered that was after closing. AC after closing. So out of the old car, I only need A and C after closing. So, like I said, knowing the acronyms may be helpful. Like I said, I might, when I go to test day, just write down old car and underline the C and the A, because these are the things that after closing AC, accounting and confidentiality. So just the way tip you may want to remember that by. And agency duties to the customers. We owe them, we owe them honesty and fairness. All right, so now we'll identify the agent duties to both the clients and customers in Virginia. So under the brokerage agreements, we are to owe them explanation and clarification. So to ensure that our clients fully understand the brokerage agreement's terms, I would familiarize yourself, like I said, get through the course first. There's a lot still to learn. But once you've completed your course and you've passed your exam, once you get to your brokerage and get signed up and set up with all your documents, I would start reading over all the documents that you need, that we need to learn. I would make sure that I know from top to bottom, and I'll just pull this up here. Making sure that I understand what my documents mean, because it is part of our duties to make sure that we are telling and explaining things how they need to be explained. So this is, are you able to see the screen that I have up here?
Yes, I am.
Yes.
So this is a database. This is zip forms, and I just got to this from my MLS, but this slide here is to ensure that the clients fully understand the brokerage agreement. So this is the brokerage agreement, exclusive rights to represent seller. Because everything is automatically filled out. Let's see. And you see, so this is the seller and then the broker. It doesn't say anything about who the agent is at all. So I'm putting my name there as the seller. And then they're under contract and a seller, they're in there legally binding with my broker. But again, you just want to make sure, that you go through and start reading these documents. So when you go through here, make this a little bit bigger, I can just hit each bullet point. So I'll say, here, this information about your property. It's just access if if it's in the water, if it's near water. This is our list price. This is our listing period from here to there. Seller representations, and I'm just going through. So familiarize yourself with these, especially these terms too. So if I'm talking to a seller and I'm going over this purchase, this listing agreement, which is 8 pages long, I'm going to make sure that I highlight all the duties of the brokers, all the seller's duties, all that they're obligated to do. Seller's disclosures, again, we're seeing disclosures again because it's an important part of our contract. Material information. So like I said, once you get access, just read through. It is a lot of language, new words. It's very like legal kind of language, but just make sure that when you're going through it, you're not just sending people there to click on things and sign here, sign there. Take them through it, familiarize yourself with it. Now they don't have to know what every line means, and I might just go here and I might just highlight, or put a big circle in a red pen or whatever, that you want to really take importance of these topics here, but you kind of do want to make sure you familiarize yourself, so that they understand the brokerage agreement, When it comes to drafting your presentation, you should be able to prepare, present, and customize the brokerage agreement. Again, knowing where to put what, where to state this, where to state that. Another duty is compliance and documentation. So ensure that you're legally compliant. You've provided signed copies to your clients. You've put them, put them safely where they needed to be. That you've upholded to your fiduciary duties outlined in the agreement, and negotiation and termination. So negotiating terms and managing terminations or renewals. So it is our job to negotiate. It is our job, and sometimes sellers just make it easy. You have a sweet deal, everybody's able to come up on good terms. But like I said, things also may come up during the transaction. You still have to have that negotiator hat on. Again, when it's dual agency, when we're representing a buyer and seller for the same property, it is legal in Virginia. We just have to have it disclosed and agreed upon in writing. Now, designated agency is when the broker assigns one agent for the seller and one for the buyer. Again, it's possible, you just need it in writing. They are going to ask you questions related to dual agency and designated agency. Just remember the two. Dual is when I have both, and designated is when the broker is designating someone to go here and someone to go on the seller side or to the buyer side. So make sure we remember the difference between those. Another thing that we need to disclose is if we have any interest into a property. So you may see some say owner agent, owner related to the seller, owner or agent is part owner to the LLC who's listing the home. So we need to always disclose anytime we are related to someone buying or selling the home, or if we have any interest of ourselves, and we must state that they are a licensed agent in Virginia. And also any material facts. So we need to disclose the property condition to both clients and customers, but the transaction information only to our clients. So an example of licensee liability, both clients and licensees are presumed to possess actual knowledge and information only. Knowledge or information among or between clients and licensees is not attributed to one or the other party. Other more specific limitations on liability are presented below. I don't think this shows. Yeah, don't know why that's there. Let's see what we have in the book. Not there either. Sorry for such a crappy example. Let me go back to this one and try to break this down some. So the clients and our sellers are presumed to have actual knowledge, meaning that they should know matter of factly what things are wrong with the home. If we don't, it's like saying that the seller may know, but the agent may not have. So although we are presumed to know, it may be that the seller, knows something and maybe didn't disclose it to the agent, or maybe we know something and we maybe not mention it to our seller thinking that they already know. So although we are presumed to know these things, still cross-check, still tell your seller if, hey, I think, there may be a problem with your foundation or your roof, and we may need to get that looked at. Don't just assume that they already know something. Just still have those conversations, because at the end of the day, you're going to be liable and it's going to be put on you if you don't know these certain things in the home, or you try to bypass it. Just like my seller who had the foundation issue, she wanted me to turn a blind eye to it. I'm like, I can't, I know about it. We have to disclose it. But if I were to see it and maybe, she hadn't mentioned it, that is like, I still have liability on myself as far as my knowledge. But let us get into this progress check. The first question is, which of the following is not subject to agent duties according to Virginia license law?
Independent contractor.
Okay. Which of the following are valid reasons for agency termination?
All of the above.
Mhm. In which fiduciary duties remain in effect even after agency termination? After closing. I'll give you a hint.
Accounting and confidentiality.
Yep. And you see, although I do suggest reading all of your answers, when you understand your vocabulary and know your acronyms and know which acronyms, it, I wouldn't, like I said, still read all of the questions, but it can make your problem solving a lot easier because you can just go and look for the answer. Not that you can bypass all of these, but if you know you're looking for duties that remain in effect after closing, you've already identified A, C, and so you just look for the answer. So as I said, vocabulary is very important because it can help you identify these answers within these questions. Last question. So one broker representing two clients is what type of agency and is it allowed under Virginia law?
Dual agency and yes.
Ms. Dietrich, what do you think for this answer?
It is dual agency is allowed.
So it is allowed. I'm going to go and select dual agency because both of you said that. I'm going to check. Correct. Dual agency. One broker representing two clients.
Mhm.
Yep. Righty. Module 16, we're back here on the fair housing topics. So the purpose of the Virginia Fair Housing Act is to provide fair housing to all Commonwealth citizens, to prohibit any discriminatory practices with respect to residential housing. That's also there in place to provide peace, health, safety, prosperity, and general welfare in the Commonwealth and exercise of police power for the protection, of the Commonwealth people. So the Virginia Fair Housing Act does not apply to, this list is going to be important, privately owned single-family houses sold and rented. It does not apply to owner-occupied rooms as units, with respect of being no more than 4 units. Any religious organizations, nonprofit, non-commercial, private membership clubs do not have to abide by some of the laws in fair housing. Persons presenting clear and present danger. This act does not also apply to persons convicted of illegal manufacturing / distribution of controlled substances, and it does not apply to maximum number of occupants. So these are the list of exempts, properties that are exempt from the Virginia Fair Housing Act. This act also does not apply to persons' source of funds. So if the owner does not own more than 4 rental dwellings in the Commonwealth, the source of funds is not approved within 15 days of request of tenancy. So if the owner owns more than 4 rental dwellings in the Commonwealth, then looking into this person's funds may be something that they may be applicable to do, but it doesn't apply to them if they don't own more than 4. Virginia Fair Housing Act, how does that differ from the federal act? Again, Virginia picked up a few more protected classes. So under the Fair Housing, the Federal Fair Housing Act The protected classes are race, color, religion, national origin, sex, familial status, and disability. So under Virginia, you still must follow and not discriminate against all of the ones that classify under your federal fair housing, but Virginia and other states can also add in their own protected classes and restrictions, but the states cannot omit any federally protected classes. So they can't, we have to abide by things federal, but we can add in our own without taking away any other federal ones. So in Virginia, we've added elderliness, source of funds, and military status. And elderliness, if it's asked, we identify that as those who are 55 and older. So again, just a list, the federal compared to the ones that are only applied to in Virginia. They are not federally protected classes, but they are in the state of Virginia. Again, another acronym to remember, the federal fair housing protected classes is fresh corn. Again, another chart indicating that Virginia has added elderliness, military, and source of income. So the Real Estate Board and the Fair Housing Board are the two boards that kind of enforce this act and determine like the consequences that happen. So the victims, if they felt like they were discriminated against, they must file complaints to the board within 1 year of the violation. And they must file the complaint with the Virginia State Court within 2 years of the violation. They conduct investigations of fair housing law violations. They also attempt resolution of complaints by conference and reconciliation. They issue a charge and refer it to the Attorney General for action if deemed necessary, but it's always going to start with the board and then escalate from there. So penalties, they have fines up to $50,000 for the first violation and $100,000 for subsequent violations. There could also be an injunctive relief. There could also be attorney fees and punitive damages attached onto that as well. The licensee may also be disciplined by the board. They can be fined or have their license suspended or revoked. And those are the penalties of the violations of fair housing. We have an example. So seller A agrees to sell to buyers B on the condition that they presently have no children and do not plan to have any in the future. This violates the familial status protection under both the Virginia and Federal Fair Housing Acts. Therefore, the condition is unenforceable and void. However, if the rest of the contract is valid, the contract itself would still be enforceable. If it turns out that the buyers have children, they may ignore the condition and enforce the underlying contract. So, just speaking the whole, and let's say they present a contract and the terms were great, had the right money, but they had the stipulation about the family. They would be able to cross that out, void that part of the contract, and proceed with everything else, just not the parts that violate fair housing. Another example, if a real estate agent has a customer who makes $40,000 per year, it is not discrimination when that agent decides not to show the customer a $500,000 house. However, if she decides not to show the same customer a particular house because the customer is the minority, then the licensee is guilty of steering. So we still have that fiduciary responsibility where we have to have reasonable care. We can't let someone who only makes $40,000 a year buy a house that's $500,000. It just doesn't make sense. So that in itself would not be discriminating. But let's say there was a $500,000 house and my client is Hispanic and I say, no, we're just not going to show you that house because I don't feel you deserve or whatever. That's total discrimination. So you cannot do that, but you can have reasonable care. It's part of what we're hired to do. Let's say that you own an apartment house in Peaceful Retreat, Virginia. The dwelling contains six two-bedroom, one-bath units. You do not like children and do not want to rent to families with children. However, you do not qualify for either of the all elderly housing exemptions, so you may not discriminate against families. But since Peaceful Retreat has an ordinance that limits apartment occupancies to 4 people per bathroom, you will not violate either the Virginia or the Federal Fair Housing Act if you refuse to rent to a family of 5. So, because you own a dwelling, you can't discriminate because of families, but you can kind of tweak it and put a cap on how many members of a family are able to move into yours, because it is, what did they say? This wasn't an ordinance. Could also be like a building code or fire safety hazard. So, not to say like it gives you a right to discriminate, but it allows you to have some exemptions and some ways to kind of move around that. So again, I told you these chapters were very, very short, just kind of reiterating some things that we've already talked about, applying it specifically to Virginia. The first question on this progress check is the Virginia Fair Housing Law is more restrictive than the federal law in that it adds military status, source of income, and elderly as a protected class. In Virginia, elderly is defined as any natural person who is what age and older?
55.
Yep, that's so young, but they consider it to be elderly. And so Keller Kinney hired licensee Luigi to get his property on the market, but shortly after the listing was posted, Kinney felt that he was a victim of discrimination and Luigi had violated the federal fair housing law. How long does Kinney have to file a complaint with the board?
1 year.
Yeah. And so remember, it's 2 years for the courts. So 1 year with the board, 2 years with the court. And this is specifically asking about the board. If licensee Luigi is found to have violated fair housing laws, his penalties could include all of the following except what?
Incarceration.
Yeah. So again, anything criminal, jail time, all of that's going to be handled by something else. Virginia, we don't get into any of that. It's a possibility that it could lead there. You've done something crazy, but the board won't put you in jail. So gender identity and sexual orientation were established as a protected class under which law?
The fair housing law.
Which one? B or D?
Oh, sorry. Federal fair housing law.
Yeah. Yeah, under the federal ones. So fair housing is going to be big. I see it all the time in like my realtor groups, and I think I read you an example last week about a guy being asked to pay like the full year's rent because he had his kids part-time. So fair housing, you'll see kind of people will try, and this most of the time is your customers trying to go about things that are different. Was working with a family. They inherited their mom's house, and they previously had people come by and try to buy it. I think one time it was some house flippers, and they were white males, like a group of investors. And one of the sisters was like, I don't want to have a white, but she said, I don't want to have a white person have my home. And I said, well, you can't hire me because I can't discriminate. Or for one, I just don't know why you would want to be so, rude. If you want to do that on your own and sell your own house, but as me, I cannot break the law for you, Mr. Seller. And I had to, have that conversation. Like that is against the law to discriminate who's able to buy. fair housing is a lot when it comes to, appraisals. Sometimes it has been said that minority families don't get the right value of their home when, appraisers come in. So oftentimes they pull down pictures to indicate, what race or, nationality, origin, someone lives. But I always instruct my sellers just to depersonalize your home, take down any family pictures, and because you never know who's walking into your home, But on top of that, just to avoid any fair housing, just to, you know, I would just go ahead and take that down. But fair housing is probably going to be the biggest outside of like disclosing things. With that, it's kind of you have to prove that the seller one knew about it, or try to hide it or something like that. But on top of disclosures, I think fair housing is probably one of the biggest things because it can be a lot of little things. Like I said, the one guy, it's just about the source of income and the familial status. So there can be a lot of different things that fall under the fair housing. But it's like I said, it's a big one. And you'll have plenty of questions on your exam about that. So, specific acts pertaining to real estate practice, section 17. You'll have 4 questions on your exam relating to this topic. So these are all about Condominium Acts, Timeshare Act, Residential Landlord Tenant Act, Underground Utility Damage Prevention Act, and the Owners Property Association Act. Oops. So Virginia Condominium Act and Regulations. So they are defining a condominium. Again, I like to look at these almost like apartments. So you own your individual unit, and there are other portions that are owned in common with other tenants in the area. So it may be a gym, a basketball court, I don't know, swimming pool, park, designated areas that everyone is allowed to use. So the unit, again, will be described as the individual's portion, and then the common elements would be shared amongst the units of the whole complex. So within the Virginia Condominium Act, it's governed and managed by the Virginia Real Estate Board. There's a reference of this found in Title 55.1, Chapter 19 of the Code of Virginia. The purpose provides legal framework for the creation, management, and regulation of condominiums in Virginia. It establishes the bylaws, so the internal management rules of the condominium association. They have regular meetings that the unit owners must be there or conduct. They have a board of directors. Now, they are the ones that are going to be responsible for enforcing these rules and regulations and managing the condominium property. And then there also should be in place a dispute resolution. It's going to describe and lay out the process for resolving these hiccups or disputes between the unit owners and the association. CC and Rs, they're covenants, conditions, and restrictions. Another acronym for you. So what they do is they outline the regulations and the use for the condominium units and the common areas. It lays out, the hours of operation maybe for the laundry area, and maybe what type of payments are accepted in the laundry, or how long you're able to leave your clothes in the dryer after they've dried. A lot of these things can be a lot of details. So if they are to amend anything out of these CCNRs, they need to have a majority vote of the unit owners. And to enforce this, it's going to be enforced and managed by the Condominium Association's Board of Directors. Unit owner restrictions. So alterations, you may need approval from the association to make any significant changes to your units. Usage, units may have restrictions on running a business or subleasing. There are also restrictions about the maintenance. The owners maintain their units, but there also may be some things that the association takes care of, whether it be snow plowing, raking the leaves, um, mowing the grass, maintaining like landscaping. So those things are maybe something that the condominium association takes care of with their fees. Assessments. The owners must pay regular assessments for the maintenance of the common elements. Again, your monthly or annual fee. And there is a restriction on the amount of noise and nuances that they're able to, so keep everything like at a minimum. Let me see something here. I'm gonna show you at the end. I just had a HOA come across my email yesterday, so I'll show you exactly all the details of one once we finish this section. But the Virginia Timeshare Act, again, you'll find it here, Chapter 22 of the Code of Virginia. The purpose, it regulates the creation, management, and sale of timeshares in Virginia to protect the customers and ensure fair practices. So the definition of a timeshare is a property with multiple owners. So each has the right to use the property for a specific period of time annually each year. So some things that you might see within this act is that these timeshare programs need to be registered with the Virginia Board of Real Estate before offering them for sale. The declarant is going to be the owner or the developer. They must also provide public offering statement to the buyers. Again, step 2 is going to go a lot in detail of this, like the initial sale versus the resale periods and the recessions that go into all of that. You'll get that in section 2. The associations must adopt the bylaws. And owners are required to pay annual maintenance fees on the timeshares, according to the Timeshare Act. Now the Virginia Landlord Tenant Act, it applies to all residential rental agreement. However, it does not apply to HUD-related public housing, commercial property, institutions like prisons, social organizations, fraternity, frat houses, campgrounds, landlord employees, like the maintenance staff who may be living in an apartment on site, hotels or motels, or 2 or fewer houses for rent. The fees, this section of the Landlord Tenant Act allows the landlords to assess fees. They're usually application fees, security deposit fees. You may also see like a pet fee, no smoking fee, those type of things. So those fees, go back here. It is allowed. So a lot of times people don't like or application fees and background check fees. It's there. It's part of Virginia Landlord Tenant Act. They are within every law abiding duty to be able to charge you those fees. So the lease's violations. A tenant can violate by being late on payments. And let's see, you need to give a 5-day notice after 5 days of not being paid. And give them 21 days to correct. And the tenant may also be eligible to give a landlord 30 days to correct anything that is wrong with the property in itself. And again, I had to do that by calling the code enforcement for things that my landlord didn't have right at the time. And they, gave him exactly 30 days to get it corrected or he would be fined. Now, something new is the Virginia Underground Utility Damage Prevention Act. And this prevents damage to any underground utility lines during any excavation activities. So what usually needs to happen is that they need to contact Miss Utility at least 48 hours before digging to make sure that the specific location that they're in is not going to disrupt anything that may be built underground. They must mark the location of the underground facilities within 48 hours of notification. So it's like I said, it's all a process. We work with a lot of different organizations and departments within the city. So before anybody's able to just go digging, someone needs to go out and mark where there may be underground facilities, pipes, wires, all of those things, so that way anybody that's doing construction does not damage those lines. Those markings are usually made with little colored flags, stakes, or paint. They use red for electric and yellow for gas. Now, tolerance zones, they are a safety buffer near marked utility lines. So within those tolerance zones, excavation is restricted, hand digging is required. So I would say that's kind of like a more sensitive area. You want to just be more delicate, and that's where they're asking not to use any heavy machinery, but to go in there with your hands or your hand tools to get through that where you need to be. The excavator duties. Verify markings before starting to work. Protect markings during the project. Report any damage to utility lines immediately. Be a lot of damage to those things just when you think about, someone out here doing cable. Last week, the internet cut off and cable, so you just have to be careful, report those immediately so that way, like AEP or whoever, you know, sponsoring that area or has coverage over that is able to alert people in that neighborhood. Non-compliance and not calling before you dig or not, abiding by the markers can result in some civil penalties and fines. And all of these are enforced by the Virginia State Corporation Commission, so the SCC. Now, the Virginia POA acts a little bit similar to the Condominium Association, but they regulate the provisions, operations, and associations of developments and subdivisions. Again, this could affect the actual property, the lots, the common areas of the subdivision as well. So the POA Act is not applicable to developments prior to January 1st, 1959. Developments that are already in a condominium act, cooperative act, timeshare, or membership camping act. They're not also applicable to non-stock, nonprofit, taxable corporations that make public recreational facilities. So like ski lounges, golf courses, those type of things are not, the Virginia POA would not be applicable to those type of places. And they do require proper disclosures. Now, the seller must provide an association disclosure packet from the POA to the buyer. The packet must be current and include date of printing. The association shall deliver the disclosure packet within 14 days of the seller's request. This is also important to know these type of things, especially when getting into a contract. So there's a part of our purchase agreement where it talks about, see if I can pull that up. It talks about us getting, or if a home is located within a POA. Wanted to see if I can pull it back up, but worse than that, but I want to show you a real HOA document that I got just the other day. But again, it's in your purchase agreement on if an HOA packet is requested. Again, the sellers have to reach out to the POA and they have to deliver it to the seller, but their time frame for that is within 14 days. Now, a POA packet is not required if the property is transferred by gift, by court order, foreclosure, if it's sold at an auction, or a person who is not acquiring the lot for his own residence. It's not required in any of those. Right of recession, 3 days after ratification of receipt of disclosure packet. So the buyers are able to terminate if they do not feel like any of the things in this property or POA packet is feasible for them. So I think I talked the other day about a client that I'm working with who inherited a home. It is within a POA area. Where is my link? And so she wants to rent it out. And I saw, are you still able to see? Pull this up.
Yes.
Yes.
So, I forgot what I was saying. Oh, so her home that she inherited is in an HOA community. She wants to be able to rent it. And I said, well, we have to check with the HOA for one to make sure that that's allowed. And then and I'm property managing it for her. It's another stream of income you can have with real estate. But I'm property managing it, so I also need to make sure that the tenants know what's allowed in the homeowners association. So this is a disclosure packet. So when all the examples we just talked about, when it talks about packets, this is exactly what they're talking about. This is 27 pages long. Again, it starts off by saying these are the bylaws of the Highlands Homeowner Association. Talks about the office. Again, we talk about board of directors. Again, we talked about certain things being able to be changed by the board of directors. It talks about the meetings, how they are elected, special meetings, notice. All of these things really don't matter. What I did find interesting was in section 10 that these board of directors may be compensated for their time of being on the board. That was different. Talked about how to remove directors, what happens if someone is absent, or what this says, assent. I'm not even sure what that means, but let's see. Again, all of this information is about the board, more information about the board, about officers, how they are elected, duties of the president, blah, 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 secretary. So everybody, so these are all members. Everybody has their own special, duty within this particular subdivision's board. As the vice president, they're all in his duties. They talk about the bank accounts. They talk about the salaries of anybody on the board, any additional committees that might be a result of the board. So contracts, loans, and checks and deposits. So these HOAs are, like I said, they cover a lot. They line out the fiscal year. Their year, according to them, January 1 of 31. Same calendar year. Amendments, all of that. So that was just 8 pages of just how the board operates and their things. Annual meetings of the board of directors. So this last thing should have been updated, but they may not have updated this in 2023 or 2003. So this is information about the day that they had this meeting minutes, who all was on the board, and signed by the chairman and secretary. Still a whole lot of stuff. Nothing definitions. So they just go out defining things that are going to be. So when they talk about, when you hear declaring, whereas we're talking about this subdivision here, located in the plat book number 21, all these things to identify which community that they're referring to. They go over the definition of a declaration, so it's kind of setting the framework. When we talk about lot, that shall mean referring to any parcel of real property designated as a lot on the recorded subdivision plat for this subdivision. When they talk about owner, they shall refer to the owner on record, whether it's one or more persons or entities, um, if they merge any lots. So, I want to get down to the good part. So this is all, so Article 2 is permitted uses and restrictions. So this is what you're going to be going through line by line and having your buyers, like I said, Virginia is a buyer beware state. So your buyers, although not to say that this should be read only by your buyers, you want to be knowledgeable of it too. But again, skimming through, like I know, like all of these things really don't apply to what I am trying to get to here. Our information starts on page 13. And so this goes over the permitted uses, easement restrictions for all property within the subdivision. And so the first thing that I see, and I sent this to my client, I'm like, so the lots shall be used, improved, and devoted exclusively for single-family residential purposes, excluding the leases of any lot by the owner from time to time. So based off that, I think this says within all this legal lawyer language that she is not eligible to lease or rent out her property. Again, I'm just going to double check and make sure with the HOA. They should have emailed me today, but I'll follow back up with them tomorrow to see, hey, section 1 says this. Can we, move forward? Let's say, so right here it says no building shall be erected, altered, or placed or permitted to remain on any lot. So or other structures built by the declarant or approved. So meaning you can't go and put up, extra garages or extra sheds. There's something else crazy they said in here. Animals. So no birds other than reasonable number of generally recognized house or yard pets. And this is funny, like generally recognized. So we don't want you with any like crazy exotic cats and things like that. They have to be generally recognized. They shall be maintained on any property within only if they are kept as domestic pets, not for commercial purposes. So that could also be maybe not breeding animals, because it could fall into commercial purposes at that, No animal shall be allowed to make an unreasonable amount of noise or become a nuisance. Antennas. So antennas are mentioned in this HOA. Um, So if you do have a satellite, they cannot be in excess of 24 inches in diameter, and not be visible from any street within the subdivision. Utility services. So, I mean, it goes pretty deep. So no trailers, incomplete building, tent, shack, garage, or barn, no temporary buildings or structure of any kind shall be used at any time on any property within the property. So trailers and motor vehicles. I think this talks about not having boats. You can't park in a yard, and I really like this. So no, I think it even says they can't work on their cars.
Hey,
Let me see.
Ashley,
Yeah,
are we supposed to be seeing something different on your screen other than the
let me
last
see.
page?
Oh, yes, I'm sorry. Hold on. Thanks
No,
for
you're
speaking
fine. I
up.
was like, I don't know what I'm reading.
Can you see it now?
Yes.
Oh gosh, thank you. So let me go back up to the top. So all of this is the HOA packet that I got from my client. So all of this just talks about the board. So these pages here are what I was going through about, who's on the board, what is the definition, who is the secretary, the duties of the president, the chairman, and all of that. What really matters in this HOA starts on page 13. And these are all the restrictions and uses of the property. So talked about the animals, the satellite antennas. It talked about trailers and motor vehicles. So licensed automobiles shall stay parked within the front yard for no more than 24 hours. This one says no motor vehicle shall be constructed, reconstructed, or repaired upon the front or side yards of any property on the street. I think that's kind of absurd. Like I can't change my, water fluid or whatever, the windshield wiper fluid in my driveway. I mean, so I'm sure nobody's going to like try to snitch on the HOA, but it is laid out that you are not supposed to be repairing your car on the front or sides of your property. No motor vehicle should be parked on any lots other than the driveways. They talk about easements, they talk about exterior lighting, maintenance of the lawn, they talk about that, landscaping. All landscaping should be installed within 60 days of completion of the construction. Nuances, repairs to the building, trash collection. They're not even allowed to put clothes dryer things up. So they cannot erect any clotheslines in the property. Encroachment. So some of these are not always so picky. Some of these are laughable sometimes, but like I said, it upholds the standard of the community. They talked about signs. Like I think they're allowed to have realtor signs, yeah, but they are no larger than 2 feet by 3 feet. So now I have to measure my signs to make sure that they are not, against the subdivision's request. And talk about easements. So sometimes these things can be a lot more specific. I've read one to where they were not allowed to, like if they were to build a deck, they have to get it approved by the HOA, but it has to be of this material. So you can't just do any old regular wooden deck. It has to be like the Trex deck. And that's like the most expensive type of material you can use, but it was laid out in their HOA. Some of them said you couldn't grill or they can't have anything like cookware equipment outside. So those were two big red flags for my client. He's like, you can't tell me I'm a grown man. You can't tell me I can't grill. So I mean, he's within his rights, but so are, the HOA community. So my client is not very happy with, and I'll show you again where it says, and you let me know what you think, but I don't think she's allowed to rent. And I say a lot of this is in legal language, but let's see, where is this at? So this here is where I'm thinking that it says that she can't lease. Um, so like I think that's what it means. I just want clarification. But this is the reason why I wanted to have the HOA. So I know specifically what can and cannot be done on that specific property. But this is an example of what an HOA packet may look like. Again, this is only 27 pages. I've had some that are like 84. But again, it is up to the client to do their due diligence. Talk about the pets, the antennas, so they can get very, very specific about those things. So let's see. All right, are you still able to see the Moseley screen now?
Yes.
Okay. So go ahead and do our progress check for this chapter. So the Virginia Landlord Tenant Act applies to what?
Residential lease agreements.
Correct. All right, so under the Virginia Underground Utility Damage Prevention Act, excavators must contact Virginia 811 Missed Utility at least how many hours before digging?
48.
Yes. Okay, and under the Virginia Condominium Act, unit owners must get approval from who to make significant changes to their units?
The condominium association.
Yeah. I also want to stop here and say this. You may also have to contact the board, but yes, you're correct. So the condominium association will yay or nay, their decision, but depending on the scope of work that they're trying to do, you may have to also call the zoning board. But the correct answer is yes, the condominium association when it relates to that. The Virginia POA Act applies to what?
Subdivisions.
Correct. All right. So you guys, we are officially done with step one of your Moseley real estate course. Like I said, these last few topics are just brushing over what all we've gone through in some previous chapters. Next, you'll start on like I said, section 2. And let's just go into section 4 here to show what these look like. Again, through a little bit of the same, what we've already gone through, it'll look the same. Just like I said, more verbiage, more definition, more real, concepts and things. Everything is still kind of broken down in the same way. As far as like topics, I think it's just a few more information. They'll talk about what's going on like in the screening. So just breaking everything down and expanding a little bit more. So I'm just going through so you can see kind of what the rest of things would look like. Hopefully you started on some of section 2. And then at the end, you'll have your progress check, just like we have had in our classes here. I would go ahead and make sure that all of your progress check answers are logged for step 1. But after today, you are on your own. I am still available via text and email. You come across anything, if there's anything Moseley specific, like you're having issues with your site or things like that, if you need to contact Moseley directly, reach out to me and I can give you the my correspondence number. Like I said, after step 2, you just follow along and everything will go in order. So we've just finished step 1. Step 2 and 3, kind of on your own. Step 4, all of that will be step 4, 5, and 6 are all testing. So you really have step 2, just the going kind of refreshing, expanding on what you already learned. And then from the rest, it's just more practice questions, like mini quizzes and things like that off of each subject. So don't want to confuse you, but a tip to get through the course a little bit faster is, let's say, like I said, we've done step 1, now you're operating out of step 2. So I would go through and do all of step 1. And this is how I'm taking my broker's course. So I'm in the same kind of format and layout you are. But what I do, go through step 1, then I start with step 2. I finish everything in module 1. So I go through 1.1 through 1.4. And then I go to step 3 and I quiz myself on module 1. And I do that until I get a 70 or 75 or above. Then I go back and then I do everything for step 2. I go to 2.1 all the way to 2.5 in step 2, and then I go and do a quiz under step 3. So you can do it back and forth like that if you like. I just think it helps kind of gets you towards the finish line a little bit faster. But if you want to go through it, take each section step by step and go through it that way, you're more than welcome to. Like I said, it's just a way that I think that you can get past this and you can stay on your goal to possibly have this completed and possibly be testing with the PSI exam by the end of this year. But I would still try to dedicate maybe Tuesday and Thursdays just to be your Moseley days, just so you can set up your hours, get through here. Nothing, another course says you need to take 60 hours. There may be, I think there is one of these that times you on how long you've taken, but it's nobody's keeping track of how many hours. As long as you've completed it, you would have been considered to have completed your 60 hours. Um, any questions about what we've gone over or what is expected of you going forward?
No, I think I'm good.
Okay. How are you feeling about going forward without like guidance from a trainer? Are you all confident in going into step 2?
I feel like I am.
Okay, 'cause I
Yeah,
was gonna say if not, we can meet again Thursday and just retouch on some things. But it's pretty self-guided from here. A lot of the questions you'll see, you might see them repeated. But what I like is like pay very close attention because I'm not sure how they got these questions to be so much similar to what's on the PXI exam. But you'll take these and then you'll get to the exam and you're like, wow, this is, I already know the answer because Mosley has quizzed me twice in 3 different sections on this. So I really do like that. I love that step 3 is able to break down and give you kind of like the end of our progress check where it gives us, let's see, where it gives us these, it gives us whether the correct answer is, and it gives us more. So it's like, oh, okay, I got it wrong because I thought it was permanent fixture and not trade fixture. So I really, really like step 3. um, because it can break it down, so you're still kind of your quiz, but you're also getting like a mini shot of a refresher with these, and it gives it to you for even the answers that you've gotten right. Um, so I really enjoy going over step 3. Like I said, even in my broker's classes that I'm in now, I'm like, oh, I'm going through because it's basically the same stuff that we've gone through here um in the principles class, the one you're taking. So I just go to step 3 and quiz myself because I know the quizzes are going to help me prepare to take my exam. Um, and then again, you have step 4, which are practice exams. You have 2 of those, both 120 questions. And these are timed, but I think you're going to be pretty much set. Um, Also, I want to remind you, your book doesn't have like a glossary, like, back of your textbook normally would have it, but you do have all of your information here. So you have um, your web version of your glossary and a PDF version if you're more of a, pen, paper, highlighter type of person. You can print them out and maybe, cut them up, put them on flashcards. Um, but all of those things are going to be here. Once you've completed everything and you are ready to take your licensing exam, under here, there's some more practice quizzes, and then you can, like I said, quiz yourself on each of the topics. So after step 2, it's really just preparing you to take the exam, and I think you're going to do great because they don't leave anything like anything left out. Again, you do have options to use Moseley again as your career moves forward for your post-licensing and your CE credits. You have all of that there. Everything else you need will be inside of your Moseley site. Um, Again, all of these courses are valid for 12 months from the date of purchase. If, for reason life happened, you don't continue to stick to your schedule, and here it comes almost well, you all would have joined in August, gets back maybe June and July, you can ask them to extend it if you need that more time, just to get past some of your things. So should be very flexible with that. But I wish you all the best of luck. We will not meet on Thursday. We've completed everything, but if you feel like maybe excuse me, you need to, pick my brain about certain things. Maybe you need to elaborate on a few more things. Like I said, feel free to contact me. I'll try to send out just periodic emails just to check in with everybody, make sure that you're still on track with step 2 and that you're getting through to your material. So I'll try not to just ghost you after this last and final class. If for any reason, like I said, you need help picking out a brokerage, you feel like you want a new agent mentor, somebody to help, after the courses, but help get your business set up, branding started, those type of things, reach out to me. I'll be love to help you get started, set up with that. Same thing you just need to cry and vent about. We need each other in the real estate world. So I'm here to be a vent piece as well. Because you'll have those moments. It's always not fun and easy. So you will have those challenging times. So even if we don't end up at the same firm, just know that you have me as a colleague that can have your back or give you some type of guidance. So like I said, just a place to hear you vent about some of the crazy things your clients have done. But I truly do wish you all the best. I think it's an exciting career to be in. It's very lucrative, very flexible with your schedule. And like I said, you can do this part-time, you can do this full-time. The possibilities are endless. There's numerous avenues that you can go down into real estate. So I just wish you continue to stay dedicated to, twice a week, Tuesday and Thursdays, completing it, getting through it. If you get stuck, reach back out to me. But I truly do wish you all the best and thank you for attending my class and sticking with me through the end.
Thank you so much.
You're welcome.
Thank you so much.
You're welcome. You'll have a good rest of your night and good luck moving forward.
All right, I will be reaching out to you.
No problem. I look forward to seeing you all out in the field.
All right, thank you.
All right, bye-bye.
Bye-bye.